Principle 9. Decide whether to permit third-party observers and/or recording devices into the interview. Yeah. Well, let's talk about third parties. In my view, this is generally at the discretion of the examiner, unless you are in a one-party state. What does it mean to be in a one-party state? It means that in a one-party state, a person can record a conversation as long as one party is knowledgeable of the recording, the other party does not have to be informed. That's a very ugly rule, but there's a lot of states that have one-party states.
Hawaii.
Hawaii is a one-party state. Yeah. So my assumption in Hawaii is that all of my evaluations are recorded. I just assume that they are. In Oregon, it's a two-party state, and the recording cannot be used in any kind of civil proceeding. Courts aren't going to permit it. And federal court won't permit it if it's a one-party state. So the federal court in that jurisdiction won't permit it to be used. I had an examinee try to do that one time on a telephone recording he made of a conversation he had with me. So you should know whether you're in a one-party state or a two-party state. If you're in a one-party state, I would routinely record my evaluations because I would just assume he or she is, so I probably ought to have one too. In a two-party state, you just make your decision and decide from there.
And California is?
I don't recall. Is it a two-party state? Okay. The question was whether California is a one-party or a two-party state, San Diego, and I said I don't know, and Ann said she thinks it's a two-party state, or it is a two-party state. Yeah. Now, Otto and Krauss have a really terrific and I think very thought-provoking article in, Tom, do you know what article they published this in on third-party observers? Well, if you Google Otto and Krauss 2009, you'll get it, or do the APA search, and I can also locate it for you. But actually, it's in my chapter, and I can pull that out in a moment. They point out that there are other factors common to a psychological evaluation that can have a greater or similar effect on the psychological evaluation process, but that are well tolerated by psychologists. For example, we will say, oh, I can't have a microphone or a video or an observer here because that would make it non-standardized and I wouldn't know. But they'll have an intern sit in. Hello, why is one okay and the other one's not? It's not a standardized process. Or you'll do other things that are non-standardized in the evaluation and yet claim that you can't do so. Their argument is this is a really disingenuous argument, and that there is no evidence that a third-party observer, or as long as they're a potted plant and not interacting, but a third-party observer or a video recording or an audio recording introduces anything into the process except the potential for an adversarial context. And that, of course, can be controlled. So they think that what we're doing is being a little bit turf protective. And we think that maybe we can protect lower our liability by not having anybody else around. I'm not sure that's true. It's probably a good argument. Many of you may already routinely record your evaluations. I don't, but I think it's a good idea. Still, my practice is still morphing, if you will, still maturing. And so I think there's going to become a time that I will routinely record my fitness evaluation.
And make copies available to the examinee, because I can see that happening.
No, I would probably only do so if I were compelled to. Yeah. Just like with my other records. I don't know that I would routinely provide anything to the examinee. No.
So if he or she asks, you press the record?
I never give anything to the employee just because he or she asks. Okay. Except name, rank, and serial number.
Really?
Yeah.
Yeah.
I mean,
Take
except what I
yourself.
give in the disclosure statement. Okay.
That was
Well,
it.
let's look at what's.
Assessment.
Pardon me?
Assessment was the journal on the auto and crash.
Assessment, thank you.
Audio only versus video, comments on that?
Well, you know, I think video provides rich data, but I'm a little bit more anxious about just putting a camera on somebody. Now, there are some low-profile ones, you know, like the little, what do they call these? Like a USB,
Just
the
from
flip. But the flip has a limited recording time.
Just from a laptop camera.
You can do it from a laptop camera, absolutely. So I think it provides richer data. I would just be capturing the examinee. Yes.
I do a lot of interview research, and you have to be careful because it's a very clear guideline how you set up the video, because it's been found to make them look better or worse, depending on how you set it up. So you need to follow those video guidelines very carefully.
All right, good advice. Now, there are also Weingarten rights, and very briefly, Weingarten rights pertain to the rights of an employee who's represented in a collective bargaining group. And they are under federal law regarded as being allowed, should they request, to have a third party present in any compulsory interview in which disciplinary action may be an outcome. Now you're thinking, well, this is a fitness for duty evaluation. Disciplinary action may not be an outcome. That's not necessarily true.
Right.
They could disclose information in the context of a fitness for duty evaluation that would result in disciplinary action. And is termination considered disciplinary? Well, I mean, it's the worst possible outcome of all the disciplinary procedures. So I think it's probably a little superficial in our analysis to say, well, it's not discipline, it's just being medically removed. So in my perspective, if I have a Weingarten request, absolutely, bring them in, sit them down, but they have to shut up. They're not entitled to interact. They're not entitled to whisper in his ear or to give counsel. They're only there to be an observer. And I would ask that they sit behind, you know, so that the person is not viewed as, you know, so they're not looking at them. I don't want that distraction, but they're certainly free. If they make a Weingarten request, I'm going to do it. Now, if you're uncomfortable with any of these things, video, audio, third-party observers, you're free to simply say, I don't want to do the evaluation. Send it to somebody else. Yes, Joe?
Just to be clear on the audio, would you permit an individual to record the interview without you recording it?
I would not permit an examinee to record the interview without me recording it.
Okay.
No way. If they're recording, I'm recording. Now I say that, but in Hawaii I don't record, and I yet assume that when they put that cell phone right down between them and me, they're recording. Yeah, but you know, I should record it. I'm just mindful that I'm being recorded.
I had an examinee once who insisted on recording it. I wouldn't permit him to bring anybody in, and then I ended the examination, and he was subsequently terminated for insubordination.
So a police officer demanded to record, you wouldn't allow it, and he was fired for insubordination. Okay, well I bet he thinks twice about that one. Okay, so here are some, in your materials are some cases involving third parties at fitness for duty evaluations. And the general crux of these, and one of these is a California case, Raggi versus MCA Universal Studios, where the federal district court in Central California denied a petition to force a psychologist to permit a third party at a fitness evaluation. And the court said that third party observers may, regardless of their good intentions, contaminate a mental examination. Nolan, Tomlin, Gallietti, Vinson, all reached similar conclusions. In Vinson, the court said, pardon me, in Vinson, the court said, we were skeptical that a lawyer unschooled in the ways of the mental health profession would be able to discern the psychiatric relevance of the questions. And the examiner should have the freedom to probe deeply into the plaintiff's psyche without interference by a third party. But then Vincent argued that the presence of counsel would provide her with comfort and support in an adversarial setting. And the court responded, an examinee could view almost any examination of this sort, even by her own expert, as somewhat hostile. Whatever comfort her attorney's hand-holding might afford was substantially outweighed by the distraction and potential disruption caused by the presence of a third person. We concluded counsel's presence was not necessary. Now, you're going to find other court cases that may reach a different conclusion. I think ultimately, since we're talking in these cases about court-ordered evaluations, and those are very, very different proceedings. Not all of them. Some of these are not. But it's a very different scenario. The court's going to make that determination. But no matter what the decision, you are free to say, here's what my comfort level is, and to say no to it, just as Joe did. I'm always very clear with the person who wants to walk out of an evaluation that by all means, the door swings both ways, feel free. I never block a door.
This is smart.
No. Feel free. I respect it. But I want to make sure you understand there may be some significant consequences with your employer for this decision. You may want to think about it. You may want to consult your attorney. You may want to talk to your union steward before you make that decision. Would you like a little time to step outside and have that conversation? I'm not trying to threaten them. I want them to know this could have repercussions.